Welcome to another deep dive. You know how this works. We take your sources and we pull out the important stuff.
That's right.
And today we're looking at something pretty heavy, I guess you could say. We're going to be looking at the legal distinctions between different kinds of unlawful killing.
Big topic.
Yeah. And the document we're looking at is called Angkor Bauk Aya. Angkor. Ain't it Paul Io? A Paul Yao.
Okay.
Which, if my Sinhal is correct, translates to...
Culpable homicide and murder.
That's right. And we're going to be looking at it from a criminal law perspective.
Yeah, I mean, this is a subject that, goes really deep. Right? I mean, you could think about it almost from like an anthropological perspective. Like one of the earliest examples we have of codified law, like Hammurabi's Code way back in ancient Babylon, had that famous, an eye for an eye principle, lex talionis. And it just goes to show how fundamental this concept is to, how societies function, this idea of taking a life and how do you deal with that? How do you define justice?
I mean, it's the ultimate, right? The ultimate crime you can commit is to take someone's life.
Absolutely.
And it's interesting how it has evolved over time. And the law has kind of had to evolve with it. Like, for example, early English law started with a very strict view of liability. If your actions led to someone's death, you were responsible. It was almost like cause and effect.
And it makes sense, in a very, I guess, rudimentary system. But the thing is, over time, people started realizing that the mental state of the person who caused the death, really matters. Like, what was going on in their head? Was it an accident? Did they mean to do it? Were they even aware of what they were doing?
Yeah, was there malice?
Right, exactly. And as those considerations started to come into play, it led to this kind of differentiation in how homicide was viewed and ultimately categorized, right?
And that's where we get those three main categories that emerge, right? You've got excusable homicide,
right,
where there's no criminal blame. You've got justifiable homicide, where the killing is lawful in certain circumstances, like self-defense, for instance.
Yeah, very specific.
And then you've got unlawful homicide, and that's the big one. That's where it becomes a crime.
Right.
And it's under this unlawful homicide category that our focus today, that Sinhalese term, istya, one kismai koiksard kolusplin de, or culpable homicide, falls under the rind.
Exactly. And what we're going to do today is look at how the Sri Lankan Penal Code, which draws from both English common law and the Indian Penal Code, tackles these concepts.
Okay.
We're going to really dissect how it defines culpable homicide and how that differs from murder, Putho Islam. And by doing that, I think we can get a really nuanced understanding of how these incredibly serious acts are treated legally in a very specific context.
So let's start by going a bit deeper into this idea of unlawful homicide in Sri Lanka. Now, the document highlights that culpable homicide is like the main type of unlawful homicide. But it also mentions a couple of other types, like within that category. What are those?
So within unlawful homicide, the Sri Lankan Penal Code, at least according to this document, right, outlines three distinct subcategories. First, as you mentioned, is culpable homicide itself, and that's covered in detail in Section 293.
Okay.
Then there's causing death by a rash or negligent act that isn't considered serious enough to be culpable homicide. So there's a threshold there, right?
A level of severity.
Exactly, and that's covered in Section 298. And then the third one, and this might be surprising to some people, is suicide, which is addressed in Section 299. Now, you might think, why is suicide under unlawful homicide? But the key is the legal consequences, right?
Okay.
There are no legal consequences for the person who committed suicide.
Right.
But it's still categorized there, I guess, for completeness.
Interesting. So kind of setting the stage for, okay, this is the broader category, and then we can kind of look at the differences within it. So moving more specifically towards the core of what we're talking about today, the document mentions a historical view from a guy named Sir Edward Coke. I hope I'm pronouncing that right. Coke or Cook?
Coke, yeah. Like the...
Coca-Cola.
Yeah, exactly. Sir Edward Coke, he was like a huge figure in English common law.
Okay.
And he defined unlawful killing as the killing of a living person under the king's peace with malice aforethought. Now, that malice aforethought bit is key, right? It could be expressed, meaning like clearly stated or implied by the law itself. And the death had to occur within a year and a day of the injury. So that kind of gives you a sense of like, okay, there had to be this clear connection.
Right. Yeah. Time frame is important there.
Time frame's important. Now, obviously, the year and a day rule is pretty much gone. But that core idea of intent of a guilty mind, that's still super relevant today.
Right. So how does this historical understanding of unlawful killing with that element of malice, how does that connect with how Sri Lankan law views obiwava and a kukman fly today?
So the Sri Lankan Penal Code, specifically in sections 293 and 294, draws a very clear line between culpable homicide and murder. The key takeaway here is this. Every murder, every hudupaim is also culpable homicide, a naguban kain. But not every culpable homicide is a murder.
Got it.
It all comes down to the level of culpability.
Okay.
So think of murder as like a super culpable homicide. Like there are certain conditions related to the person's mental state and their actions that elevate it to murder.
Okay, that makes sense. So it's all about, like, the degree, right?
Exactly.
Okay, so let's break down Section 293 specifically, which defines culpable homicide, and look at its elements. The document talks about actus reus and mens rea. Now, I know those are Latin terms that are used in legal contexts all the time.
Legalese.
Yeah, exactly. Legalese. Can you explain what they mean for our listeners who might not be familiar with legal terminology?
Of course. So actus reus literally means guilty act. It's the physical part of the crime. In culpable homicide, as defined by Section 293, the actus reus is simply causing the death of another human being. Doesn't matter how it happened. Section 45 of the Penal Code clarifies that death means the death of a human being, not an animal or anything like that.
Right, so it's very specific. So the actus reus is essentially the outcome, the result. A person has died. Are there any specifics, like, about who that person can be? Any exceptions or caveats?
Yeah, there are a couple of important points here. First, under Sri Lankan law, causing the death of an unborn child isn't considered culpable homicide. Explanation 3 of Section 293 makes that clear.
Okay.
And second, the person who died doesn't necessarily have to be the intended victim.
Oh, interesting.
Section 293 has like these illustrations and explanations that kind of demonstrate this. So, for example, if you aim to hurt one person, but you accidentally end up killing someone else, that can still fall under culpable homicide.
So the intent might be directed at one person, but the outcome affects someone else, and that's still culpable homicide.
Exactly. It's about causing the death of a human being, regardless of who you were specifically targeting.
Okay, that's an important distinction. So let's dig a bit deeper into what causing death actually means in this context. What kinds of actions are we talking about?
So, causing death essentially means doing something that cuts short a human life, before its natural end. The document talks about this. And a crucial part of this is that there has to be a direct link between what the accused did and the death. Can't be too far apart in time or circumstance. And when we talk about act, it's not just doing something, right?
Okay.
It can also be failing to do something you're legally obliged to do. For example, if you see a stranger drowning and you just, watch and they die, that's not culpable homicide because you're not legally obligated to rescue them.
Right.
However, if you're a parent and you don't feed your child and they die, that could be culpable homicide through omission because you have a legal duty to care for your child.
So it's about having a legal duty and failing to fulfill it.
Exactly.
Okay, interesting. Now, what about the role of, like, words? Can words ever lead to a charge of culpable homicide? It seems a bit far-fetched, but I guess I can see how in some cases.
It's definitely a more complex area. The document actually gives an example recognized under the Indian Penal Code. If you deliberately frighten someone, knowing they have a serious heart condition and they die of a heart attack from the shock, that could be considered culpable homicide.
Wow, okay.
Similarly, if you use really abusive language with the intention of driving someone to suicide and they actually do take their own life, that could also be considered culpable homicide. But the key in both these cases is establishing a clear and direct link between the words and the death. It can't be too remote.
Right, so it has to be that the words were like a direct cause.
Exactly.
Or not just like, oh, well, they said something mean to me 6 months ago.
Exactly, yeah. It has to be that the words were like the immediate and proximate cause of the death.
Got it. And that brings us to this concept of the chain of causation. The document talks about situations where this chain might be broken. Why is that important for determining if someone is culpable for homicide?
Well, the chain of causation is fundamental, right? It establishes whether the accused's actions were the actual cause of death. If something else happens and breaks that chain, well, the accused might not be legally responsible anymore. And the document gives us some really interesting examples to show just how tricky this can get.
Let's dive into some of those examples. The first one involves a pre-existing medical condition that the accused knew about. The document references the R.V. Mendes case. What can we learn from that case?
So in R.V. Mendes, the accused injured the victim, and the victim ended up with a broken leg. Sadly, they later died from blood poisoning, which was a direct result of the broken leg. Now, the defense argued that the blood poisoning was the real cause of death, not the broken leg itself.
Okay, I see where they're going with that.
Right. But the court said, nope, because the blood poisoning was a direct consequence of the initial injury, like the broken leg got infected. The accused's actions were still considered the legal cause of death for culpable homicide.
So the infection stemmed from the injury.
Exactly.
Okay, so even if there's like a subsequent medical issue,
Yeah.
the person who caused the initial harm can still be held responsible.
Especially if that subsequent issue was a direct result of their actions, right?
Because it wouldn't have happened without that first action.
Yeah.
What about cases where medical treatment itself might be a factor? The document mentions that proper medical care could have prevented some deaths.
Yeah.
How does that affect culpability?
So Explanation 2 of Section 293 addresses this directly. It basically says that if someone dies from a physical injury, the person who inflicted that injury is still considered to have caused the death, even if proper medical care could have saved them.
Oh.
The law recognizes that the original injury was the starting point. The fact that better medical treatment might have changed the outcome doesn't change that.
So that original act is still the root cause.
Exactly.
Okay. But then the document also talks about negligent medical treatment. When does that actually break the chain of causation? Because it seems like a pretty high bar.
Oh, it is. It is a very high bar. Negligent medical treatment can only break the chain in very extreme cases. The document refers to R.V. Smith and R.V. Jordan to illustrate this. Basically, the negligence has to be so bad, so detached from the original injury, that the original wound is almost irrelevant.
Wow.
In R.V. Jordan, the victim was recovering from a stabbing, and then the medical treatment they received was completely wrong and ended up killing them. That's a broken chain. But R.V. Smith kind of set a stricter standard, saying the original injury is still the cause unless the medical negligence is so overwhelming that the original wound is basically just a side note.
Okay, so the negligence has to be incredibly egregious.
Exactly. It has to be the dominant factor.
Got it. Now, what about, like, external factors or even the victim's own actions after the initial act? How do those play into all of this?
So, for an external factor to break the chain, it can't be a direct result of the accused's actions, and it has to be significant enough to set off a whole new chain of events. The R.V. Motorman case, a good example, there was a knife attack, but then the victim died from complications during surgery to remove a blood clot.
Oh, wow.
The surgery was necessary because of the attack, but the court said it introduced a new risk, breaking the chain. On the other hand, if the victim tries to save themselves and dies as a direct result of what the accused did, those actions usually don't break the chain. Cases like Nacum kind of show that. But if the victim's reaction is totally independent and unrelated to the accused's actions, like if someone who's been robbed later has a heart attack from the stress store, the chain might be broken because the heart attack is seen as a separate, independent event.
So there's a lot of nuance there.
A lot of nuance. It all comes down to the specifics of each case.
Okay, that makes sense. The document also briefly mentions situations where a culpable act might be a combination of different actions. How do you figure out legal responsibility in those cases?
So, when a death results from a series of actions, maybe by different people, the courts look at the intent or knowledge of each person involved at the time of their specific action. Cases like Thambi Pillai v. R. and Bondu suggest that liability hinges on the mental state attached to each action.
So if one person does something and then another person does something else that ultimately leads to the death,
Yeah,
you have to look at what each person knew or intended when they did their part.
right. It's about untangling that web of actions and mental states.
Got it. Okay, so we've covered the actus reus pretty thoroughly, that guilty act. Now let's move on to mens rea,
The mental state.
the guilty mind. The document lays out 3 specific mental states that qualify for culpable homicide. What are those?
So the 3 mental states are intention to cause death, intention to cause such bodily injury as is likely to cause death, and knowledge that the act is likely to cause death. If any of these is present when the act causing death happens, boom, culpable homicide.
Okay, so let's break each of those down, starting with intention to cause death. How do you determine that someone actually intended to kill? It's not like they usually announce it beforehand, right?
No, they don't. It's not like in the movies. But there's a legal principle that guides this. Lord Ellenborough famously said, "A man is presumed to intend the natural consequences of his acts."
Okay.
So courts look at the whole picture, what the person did, how they did it, the weapon, the injuries, everything. And from that, they infer what the intention probably was.
Right, like if you stab someone repeatedly in the chest,
Yeah, it's pretty clear.
they're probably intended to kill them.
Exactly. The law assumes you understand the consequences of your actions. But this is a presumption. It can be challenged. Like, if you push someone and they fall, hit their head weirdly, and die, maybe the intention wasn't to kill, right? It was just to push them.
Yeah, it was an unfortunate accident.
Exactly. And it's also important to remember that the intention is to cause death to a person, not necessarily that specific person, like we talked about before.
Right, it doesn't have to be premeditated against a specific person.
Right.
Okay, let's move to the second mental state. Intention to cause bodily injury, likely to cause death. How is that different from just intending to kill?
It's subtle, but it's there. This is when the accused meant to hurt the victim, and they knew that that specific injury was likely to kill them. Justice Kenney said likely means a greater than 50% chance of death.
Okay, so it's like they knew the risk was high.
Exactly. The focus is on the specific injury and the knowledge that it could be fatal. Like in the Senegon-Govindan case where someone stuffed a cloth in someone else's mouth to silence them and they died, the court said, well, they must have known that was likely to kill them even if their primary goal was just to keep them quiet.
Yeah, that makes sense.
Yeah.
And in the Manna case, hitting someone on the head with a pole was seen as intending to cause an injury likely to cause death.
Right, because a reasonable person would know that hitting someone in the head with that much force could very well kill them.
Right. Okay. Last mental state. Knowledge that the act is likely to cause death. How is knowledge different from intention here?
So knowledge here means being aware with a high probability that your actions will cause death. It's not wanting to cause death, but knowing it's a likely outcome. Illustration B of Section 293 gives a good example. Person A knows person Z is behind a bush, but person B doesn't. A tells B to shoot at the bush, knowing it's likely to kill whoever's there. B shoots and kills Z. B is innocent, but A is guilty because they knew.
Wow, that's a tricky one.
Yeah. And the document stresses that this knowledge is judged based on the specific situation. An ordinarily safe act can become dangerous depending on the context. Like in the Kitabdi Mundler case, where a young boy kicked his wife and she died from a ruptured spleen.
Okay.
The court said a reasonable person would have known that kicking a frail woman like that could kill her, even if the boy didn't intend to kill her. The point is, the knowledge has to be there, and it's judged based on what a reasonable person would have known at the time.
Got it. So those are the three mental states that can make up culpable homicide. Now let's move to Section 294, which lays out when culpable homicide becomes murder. We know that all murders are culpable homicide, but not all culpable homicide is murder. Section 294 lists the circumstances that bump it up to murder. Can you walk us through those?
Yeah, Section 294 of the Sri Lankan Penal Code basically lists 4 specific situations where culpable homicide is elevated to murder. They're called the limbs of Section 294. First, if the act is done with the intention to cause death. Second, if it's done with the intention to cause bodily injury that the person knows is likely to cause death. Third, if it's done with the intention to cause bodily injury, and that injury is usually enough to cause death. And fourth, if the person knows that the act is so dangerous that it's almost certain to cause death or serious injury, and they do it anyway without a good reason.
Okay, a lot to unpack there. Let's go through each one. Starting with the first, act done with the intention to cause death. How does this definition of murder relate to the intention to cause death we talked about under culpable homicide? What makes it murder?
So this first limb is basically the most straightforward type of murder. The intention was to kill, straight up. The document explains that this intention is usually proven by looking at the evidence, like what was said, the weapon used, the injuries, the force used, all of that.
So it's really about proving that the primary goal was to end the victim's life.
Exactly. It's worth noting that this is a bit different from English law, where intending to cause really serious harm that ends up being fatal can sometimes be considered murder under the concept of implied malice. But the Sri Lankan law deals with that kind of situation in the second limb, which is a bit more nuanced.
Okay, so they've separated those out. So second limb, knowledge that the act is likely to cause the death of the person injured, and intending to cause bodily injury known to be likely to cause death. This seems to bring in the idea of, like, knowing how vulnerable the victim is.
Exactly. This is when you intentionally injure someone, but you also know that that specific injury is likely to kill that particular person. So it's not just a general knowledge of the risk of death, but a specific awareness of the victim's vulnerability.
Like if you know the person has a heart condition.
Exactly. And this limb moves away from that broad implied malice idea in English law. It's about having specific knowledge of the victim's weakness. If you know someone has a health problem and you attack them in a way that exploits that and they die, that could be murder under this limb. But if you had no idea about their health problem, it might not be.
So you're taking advantage of their specific weakness.
Right. The document mentions Justice Crozier and the thin skull theory, which basically says you take your victim as you find them, but in this limb of the Sri Lankan law, you have to actually know about that thin skull, so to speak, for it to be murder.
Wow, that's really interesting. Okay, moving on to the third limb. Bodily injury sufficient in the ordinary course of nature to cause death. This one seems to focus more on the severity of the injury itself, rather than any specific knowledge about the victim.
Exactly. Here it's about whether the injury you intended to inflict is generally fatal. Like, would it typically kill someone in the normal course of events?
Right, so it doesn't matter if you knew about any specific vulnerabilities the victim had.
Right. It's about the objective deadliness of the injury itself. The document mentions different legal interpretations of this limb. Some say you need both the intention to cause serious harm and the knowledge that it's usually fatal. Others propose a two-part test. Did you intend to cause a serious injury? And is that injury typically fatal according to medical evidence?
Right, and I guess the stabbing example where you accidentally sever an artery.
Yeah, that's a good example. If that injury is considered sufficient to cause death normally, even if you didn't mean to kill them, it could fall under this limb.
Okay, that makes sense. And
Yeah.
the versus Singh v. State of Punjab case where the guy drove a nail into someone's abdomen.
Oof, that's a rough one.
Yeah, that seems relevant here. It was all about how inherently deadly that injury was.
Definitely. The Supreme Court in that case basically said once it's proven that the injury was inflicted intentionally, the question of whether it's typically fatal becomes a purely medical one. And in that case, the injury was obviously very serious, and there was no evidence suggesting the guy didn't mean to inflict it, so it was murder under this limb.
Okay, last limb. Imminently dangerous act with knowledge of likelihood of death. How is this different from the others, especially in terms of the mental state required?
So the big difference here is that the mental state is knowledge. It's knowing your act is so dangerous that it'll probably kill someone or cause a life-threatening injury, and doing it anyway without a good reason. This often comes up when the harm isn't directed at a specific person. Like, imagine throwing a bomb into a crowd. You might not be aiming at anyone in particular.
Right, but the act itself is so dangerous.
Exactly. And that's why it can fall under this limb. The Prakash case is a good example. The document says this limb is often used when there's no specific intent to kill a particular person. It's about being reckless and disregarding the risk. And often courts will use an objective standard, asking what a reasonable person would have known about the danger.
So it's not just about any awareness of risk, it's about knowing how incredibly dangerous the act is.
Exactly. The Samapala v. the Queen case makes that clear. It has to be knowledge of a high probability of death or serious injury. And that's important because a lot of acts that might be culpable homicide under Section 293, where just knowing the likelihood of death is enough, wouldn't necessarily be murder under this limb. It has to be a much higher level of danger and knowledge.
So to summarize, what's the biggest difference between culpable homicide and murder in Sri Lankan law based on all this?
The biggest difference boils down to the specifics of intent and knowledge. Culpable homicide is about causing death with the intention to cause death, or the intention to cause an injury you know is likely to be fatal, or just knowing that your act is likely to be fatal. But murder under Section 294 requires more. It needs a clear intent to kill or deliberately causing an injury knowing it will likely kill that specific person, or intentionally causing an injury that's generally fatal, or doing something super dangerous while knowing it will probably kill someone and having no good reason for it.
Right, so it's like culpable homicide plus these aggravating factors.
Exactly. It's fascinating how the law tries to break down the mental state of the accused and the nature of their actions to figure out how serious the crime is.
Yeah, it's really complex.
It is.
And I think it speaks to how difficult it is to, really determine justice and accountability when we're talking about something as serious as taking a human life.
Absolutely. It's not a simple equation, and it leaves us with something to think about, right?
Yeah.
If you're listening to this, consider this. Are intention and knowledge the only things that matter in these cases? Or should other factors like the victim's circumstances or the broader social context also play a role? It's a conversation that deserves to continue.
Yeah, definitely food for thought. Thanks for joining us for this deep dive. We'll see you next time.
See you later.